Bob, how do you structure your opening statement, particularly paying attention to liability, injuries, and damages?
With reference to the injuries and damages, I don't like to go into great detail. I like to win the case on liability in the opening statement, and that's where my concentration lies. I do like to talk about it, however, and let them know how serious it is and what they have to look forward to. I generally like to tell them something to the effect that I am going to briefly summarize what the injuries or losses have been, depending on whether it's a business tort case or a personal injury type case. If it's a personal injury, I tell them that the doctors, very excellent, fine experts, will be here to tell them about these things in detail, and that I would like to give them just a brief overview of what those injuries and damages have been. And in that regard, I've done it many ways. One method I like to use, because I'm a great believer in the use of demonstrative evidence, and I like to use as many different types as possible, because I think when you try a lawsuit, that I heard Marshall Houts say once, he'd reviewed hundreds of transcripts, that the thing that came through to him clearly in reviewing these was that the lawyers who did the best were the ones who entertained. And I think when you try a lawsuit, you're the producer, the director, one of the chief actors, and you do want to entertain. By that I mean you want to keep them interested. You want to keep their attention. And so I like to use as many different demonstrative aids as possible. And one I like to use is the 3M overhead projector. You can use charts, and I use both usually during a trial, and others too. But I like to, and I've oftentimes made up 3 transparencies with reference to the injuries and damages. First transparency will simply be a list of the injuries which were sustained. Perhaps a broken bone, contusions and abrasions, whatever it is, 5 or 6 different injuries that were sustained, and I'll briefly discuss each of those as it's thrown up on the screen. And the reason why I like to use the 3M type of projector, and there are others, don't like to bother with turning the lights off. You have to have it all set up so that all you have to do is press the button. You have to be well organized, and you just throw it up on the screen without any waste of time. And the second transparency that I will use, or chart, is sort of an overview or a summary of the medical care and attention that the plaintiff received. For example, item number 1, hospitalization from such and such a date at such and such a hospital to such and such a date, and subsequent hospitalizations, and I'll list those. And then maybe an item for Dr. Jones and the visits with Dr. Jones. And have 8 or 10 different items, the medications and so forth, just to give an overview of the care and treatment. And then the third transparency would be the effect that these injuries have had on the client's ability to enjoy life, or how they've affected the plaintiff. The things that he can't do at all anymore, or the things that he can't do as well, and have a list of 8 or 10 or 12 of those. Having then discussed the injuries and damages, you then have to make a decision as to whether you want to go into the amount that you're going to ask for from the jury. Now, this is a hard question. My general feeling, particularly in the smaller type cases, is that I personally don't like to give them a figure in my opening statement, because you never know how the case is going to go in. It might go in real well, and you might feel you could ask for a little more. It might not go in so well, and you might want to go a little softer so as not to turn them off. So I for one, hate to commit myself in my opening statement to how much I'm going to ask for. You get into a really serious case, like a quadriplegic or something like that, where everybody knows it's worth millions of dollars. It's just a judgment call as to whether you want to tell them that you're going to be asking for $5 million and that you'll explain to them why and final argument and so forth and so on, and get them thinking in terms of big money. Many attorneys believe that you're there to get money, and you might as well start talking about it and get them psychologically attuned to this idea as soon as possible. But there is a difference in viewpoint. That's basically how I go about it.